everybody. Hello and welcome to today's episode of the POSH podcast, where Bishen and I, Bishen Jeswant is one of the youngest partners at CAM, specializing in employment and labor law and an advisor to several organizations in the space of POSH. And hi, I'm Laxmi, and I am the co-founder for Parity Consulting, a boutique firm that specializes in inclusion at the workplace. So having kind of introduced ourselves, what we're going to talk about, or I should say what we're going to continue to talk about really is the operational and implementation elements of the POSH Act at the organized workplace. So Bishen, the question I have for you right now is, the Act talks about a variety of stakeholders, right? It talks about the aggrieved woman, the woman who has a complaint. It talks about the alleged perpetrator against whom the complaint has been made. It also talks about the term employer. And it goes on to tell us a little bit about who the law considers as employers in an organizational space, right? So what happens if there is an aggrieved woman who wants to raise a complaint, and it so happens the complaint is against the managing director or the CEO of her organization? So does she go to the IC? How does she take that forward?
Hi Lakshmi, hi everyone, good day. So this question is one that all companies grapple with because many individuals can be considered as both an employee and an employer, right? Now, who is an employer? The law defines an employer, and by and large, without getting too technical, an employer is a person who is the head of the organization, who is in charge of supervision and control of the organization in general, right? Now, obviously, this cannot be hundreds of people, right? You cannot say that everybody who is managerial is an employer. That's not the case. Now, but there is also no guidance on, is it one person, is it two, is it three, right? There isn't. Let's take a pause there. Two, now, what is the ambit of the internal complaints committee? The internal now called the internal committee, the IC, right, deals only with complaints against employees. Whereas for complaints against employers and also for complaints against employees when then there are less than 10 employees, because you don't need to have an IC if you have less than 10 employees. So in those two situations, against employers and when you have less than 10 employees, against employees as well, the complaint goes to what is known as the local committee, right? Which is an geographically different organization. It's the closest committee in your vicinity for your geography, but it's not your internal committee anymore. Now, it's very clear that if it's against an employer, you must go there, right? So the answer is, if it is against your employer, in your example you gave, MD, is possibly an employer. Whereas someone like vice president, because every third person in many IT companies is a vice president, clearly a vice president is not someone who has overall supervision and control over the establishment. For a person like that, you definitely go to your internal committee. But I think the threshold is, and this is the threshold based on feeling, is that will you get justice if you raise a complaint against your MD, right? And if you think that he's the senior most guy in the company against whom I cannot reasonably get justice in fairness and an unbiased hearing when it's against him, that's probably your indication that he's an employer. Whereas for anybody who's a couple of levels junior to him, you at least feel that if this doesn't go to order, there is an internal hierarchy who I can appeal to their conscience to, appeal to them in fairness to deal with my situation. And when you feel like there is nobody like that with respect to your accused, that's when you know that it's an employer that you have a complaint against, for whom you need to go to the local committee and not the internal committee.
I do have a few specific questions related to the local committee, but before I go there, one quick maybe comment really. The Act is also reasonably supportive of the hierarchy in an organization, right? It, for example, does not say that the presiding officer must be of a higher rank within the hierarchy as compared to the respondent. I mean, just as an example, right? So we do know that there is a little bit of leeway. We also know separately, and this is where I'd like for your thoughts on this. The local committee, and it still is referred to as an LCC, right? That specification hasn't changed. The LCC tends to be, I'm going to say, kind of like a quasi-governmental committee, right? I mean, there could be a district officer, there could be somebody from the State Commission of Women, whatever, like the LCC, this thing. So it's definitely much more difficult for a complainant to, put her complaint in front of the LCC, to get the time to be calendarized, to go there for the meetings and to do all of that. So one, it's difficult for her to get justice internally. The law is designed in such a way it makes it more difficult for her when this thing. So what do you think the writers of the law, what were they thinking of when they called this out?
I think the answer is straightforward in that you have to balance justice and convenience. It is inconvenient for the victim to go to the LC because it's an external body. It is more public facing, right? You need to be more brave to get out there and put yourself out there.
Yeah.
But you have to balance that, I'm calling it convenience, versus justice. Because you cannot get justice internally is the presumption under which we're working, because it's against the senior most person in the organization whom you're calling the employer. And therefore, if you're balancing justice and convenience, justice simply wins, right? So if you want to get justice, you have to take on that little extra step of inconvenience, go to the local committee who will deal with your complaint. You must also remember, on the flip side, it is also more onerous for the respondent, right? Normally in an internal committee situation, when there is a complaint before an internal committee, at least, Matt, there is an obligation of confidentiality under the POSH Act. You know that your name will not get out there unless somehow it becomes a very high profile case and possible information gets leaked. But generally, your name will not get out there. So there is that comfort as well. Now, of course, the local committee has confidentiality obligations as well. But as soon as the complaint goes to the local committee, you are out of your comfort zone. The employer is taken out of his company and put before a local committee, which is a third party, right? You are no longer before your own people. Even if your own people are intended to be neutral and unbiased, right? There is still that comfort that it's internal, it's confidential. You've lost that. So it's harder for the respondent as well. And convenience versus justice, convenience wins. I think that's your answer.
That's interesting, because what we're seeing is, by going to the local committee, one of the things that happens is that the power and position and privilege that this MD/CEO type person has within the organization is kind of dialed down a bit, right? It is discounted because in front of the LCC, that level of privilege might not be the same. There is a little bit of the same. So two corollaries now that you've brought this up. One is, the law also says that when a complainant wants to fill in the blank, right? She wants to raise an FIR, she wants to go to the police station, the employer must support her.
Yes.
Right? So now if you're saying the employer is the MD is the person against whom the complaint has been made, how does he support a complaint against himself? So is it possible that in a case like this, the employer can refer to the legal entity, which is the organization?
So unfortunately, I shouldn't say unfortunately. So most of the obligations under the POSH Act are on the employer. So the section that you're referring to, section 19, which talks about duties of an employer to support a woman who wants to go to the cops, is a duty on the employer.
Yeah.
Right? But there is no reasonable way in which you can read employer to mean an individual in this case if the complaint is against the individual.
Yeah.
Right? So we have to, in this case, only reasonable way of reading it is to say that the employer is the organization. All the obligations that are on the employer are on the juristic person, that is the company, right? Because the company is also a juristic person in the eyes of the law, and that company is now the employer. So that's the only reasonable way to read it, because the alternate way to read it is that there is no obligation left on the employer because he's the accused, and therefore you don't have to do all of those things, which is train the IC, sensitize your people, put in place a policy, support the accused going to the cops. If there is a complaint against a third person, file it in their workplace, blah, blah, blah. There are so many obligations. You're effectively saying none of that exists because it's against the person whom you filed the complaint. So that clearly cannot be the way in which the act is intended to be read. So in these kind of situations, reasonable position would be to read employer to mean the organization, the juristic person, that is the organization.
And that's interesting. You did mention what happens in the case of an complaint being made against a respondent who is not a legal full-time employee of the organization concerned, right? So let's assume that we have a situation where person X is on contract or is an embedded service provider, and woman A is raising the complaint against person X. Can she still go to her IC?
Yeah, so I'll answer the question. But before I answer the question, I want to ask it back to you. As a member of an IC, having sat on so many ICs, I want to know from you, have you seen a case where a contract worker has been a respondent or a complainant, and what is their expectation? What does the company do? And then I'll speak about what they should be doing.
So, unfortunately, the answer is yes. We have seen cases like that. And by and large, when it is in the IT/ITES industry, which is where a lot of this embedded service provider, this thing goes on, right? By and large, we've seen a certain level of maturity in both the client organization as well as the organization that provides the service, that embeds the people, right? And therefore, it has been relatively simpler. I'm not going to say it's simple, but relatively simpler to have that conversation. To say that, hey, organization, this person whom you have sent to, my office, there is a complaint against. And we don't see that sense of, shutting down and saying, not my problem. We have not seen that yet, which is really good news. We've seen a different kind of contractor, and I'm staying again within the IT/ITES industry. So we're seeing, like, for example, transport contractors, right? Because a lot of organizations do provide the pickup and drop, but that tends to get subcontracted out, right? And over there, the conversation is slightly different because the transport vendor, unfortunately, and this has been an experience that I've had, the transport vendor tends to say, oh, if you have a complaint against driver X, don't worry about it, I'll replace driver X. Without really getting into the entire process of investigating the complaint and establishing the situation.
So, I mean, my take here is that it is inefficient for an employer to deal with a complaint against anybody who is not their employee. The reason why it's inefficient is, even if I find the person guilty, I can't take any action. For me to be able to take action against someone, I need to have control over them. And I only have control over my employees, right? So, for the benefit of the listeners, just as an example, the fact situation we are talking about is where you have, in offices, it is common to have housekeeping staff or security staff who are not your direct employees. They are engaged through an agency, right? And because they are not my employees, they are the agency's employees. Even if I have a sexual harassment proceeding against them and I find them guilty, I can't fire them. Only the agency can fire them, right? But I have an obligation as an employer to do the investigation. If my employee is harassed on my premises and comes to me and complains, of course I have to do the investigation. But it's inefficient. And therefore, what do we do in this situation, right? So in order to make this process efficient, we have to, a good practice, and this is obviously not what the law says, right? Because the law doesn't say anything. In this regard, I'm not criticizing the act just as with a broad brush. In this regard, a best practice would be for the employer and the agency providing the housekeeping staff or the security staff or the transport staff you're talking about to in the contract set out very clearly that when the complaint is to do with your personnel being the accused, the matter will be dealt with by you, assuming that the complainant, who is my employee, is comfortable with you handling the matter. So that's a contractual arrangement that we can have. Or the contractual arrangement can be that I will do the investigation and I will come up with a recommendation, but you are obligated to implement it. So at least there is some meaning for the investigation that I'm doing, right? And I think that's a possible best practice to put in place, because otherwise I can do an investigation as a formality, but that has really no meaning unless you can see end results.
Yeah. So from an IC's perspective, right, is there an obligation on the part of the IC to share this information with the complainant upfront? So something that we've kind of encouraged our clients to consider is a one-on-one conversation with a complainant when she comes forward with her written complaint, right? And we say that in that conversation, remind her of what the Act says, like you and I have talked about. Talk about the importance of confidentiality. Talk about the commitment that we, the IC, will make to her. Talk also about the process itself and say that, look, expect to experience this, and then all the other stuff, and including the cross-examination with the thing. So when it's a contract employee or it's an embedded service provider, is there an obligation on the part of the IC to include that information that, hey, we will do the investigation and we will recommend action, or that we will be passing your complaint on to the to the employer of the respondent, and you, the complainant, will need to interact with the IC of that organization?
So, a couple of things here. One, you cannot force the complainant to do anything. If the complainant has come to you, it's your obligation to carry out the investigation. So you can't say that you will now go to them. You can ask them, are you okay with you now having your complaint dealt with by G4 Securitas or TAN, whoever are these agencies who deal with housekeeping staff and security service. If they are okay with it, sure. But if they are not okay with it, you still have to deal with it. Two, you have multiple vendors, right? It's not one vendor that you're dealing with. You have housekeeping staff, gardening staff, security staff, driver staff, etc. And you probably have different contracts with each of them.
Yes.
And your arrangements with each of them may be different. With one person, you may say, I will recommend, you will implement. With another person, you may say, we will have a joint committee. With another person, you may say, if it is your employee who's accused, you will deal with it. There can be multiple arrangements. Now you can't, but you can only have one policy for your employees, right?
Yeah.
So you can let employees know by and large that if your complaints are against an accused who is not our employee, right? The manner in which the complaint is dealt with may be slightly different, but don't worry, without your consent, we won't take any action or force you to go elsewhere. So there can be a broad policy, but it can't be specific for these reasons.
So can you, or would you recommend that we actually include that particular clause in the general overall POSH policy? To say that if a complaint is made against this thing, and again, like you said, in broad terms, right?
I would. I think that's the only one good place where it can be. The place where it should be fleshed out in greater detail is in the contract that you have with the individual agencies, the service providers. So I think that's the way in which to deal with it. Here we should also talk about briefly. So in this episode, we've been talking about complaints against non-employees by and large. We said against the employer, we spoke about against contract workers. We should also touch briefly upon complaints against complete third parties, right? At least with a contract worker, you know that there is an associated agency you're dealing with who's a friendly agency who may take your recommendation on, you may help cooperate with you to deal with the situation. But imagine a situation where a salesman comes into your office from a completely unrelated third-party organization, harasses your employee and leaves, right? Your employee has been harassed in her own workplace. She will naturally come to you to deal with this complaint. But you have no authority over the random salesman who's entered your office, harassed somebody and left. So how do you deal with this, right? That's a common question that will come up as well. I mean, the law has an answer for it. The law says that you must raise the complaint in the workplace of the respondent, which makes sense, so that it is that person's employer who can punish the respondent, right? But you again can't force your complainant to go there. So you have to hope for it to work out and everybody be on the same page. Have you seen cases like this?
Again, my answer is going to be unfortunately yes. And exactly to your point, I mean, this is very much a case-by-case resolution, right? I mean, there are some instances where happily things have worked out in the sense of there's been a willingness to investigate whatever the final recommendation and stuff. But there have also been cases where organizations have they've grappled with this. It is an open question. But something that we are seeing, and to your point, that organizations are learning from this. So when something like this happens and they realize that, okay, we don't have a ready-made answer, then we know that they're looking to say, okay, how can we incorporate this learning into our employee or HR or POSH policy, as the case may be, right? So I'm going to actually loop back to where we started, which is, what happens when the complaint is against the employer and, the woman has to go to the LCC. So in a case like this where the respondent is not a full-time employee, does the premise of the law which says that if the complainant asks for support from the organization saying, hey, I don't believe in any of this, I want to go to the police station and I want to raise an FIR, does the employer of the complainant, does the employer have or are they obliged to support this woman in her choice?
So the law doesn't require the employer to support the woman in filing a complaint before the local committee, right? That's a right that she has. But the law still does require an employer to support her in filing a complaint to the police if she so wishes. So the answer to one part of the question is not really in that, not that you don't support her, but there is no active obligation to support her.
Sure.
But on the other hand, if it's to the police, there is an active obligation to support her. So that's broadly the difference between the two.
All right. Okay. So as always, Bishen, it's been exciting and interesting chatting with you.
Absolutely.
And I'm really looking forward to, doing a little bit of a deep dive into possibly another topic, which would be, but I didn't mean it. Right? Why are you being so sensitive? So this whole concept around was the intent of the person really something, or is the intent of the person something that the IC needs to take into consideration? Does the IC mandatorily have to support the complainant when she says, I felt uncomfortable, I do not really care what his intent or what his approach was? So, until next time, Bishen, and thank you as always to all of our viewers and audience. I hope that you've, I'm not going to say enjoyed the show, but I hope that you found it useful and you found it interesting, and you're going to keep coming back to us for more. So like, subscribe, and hit us up with your comments and questions. Thank you.
Thank you. Bye-bye, everybody.